Thanks so much for joining me today. Let me go ahead and share my screen here. And let me start from the top. So just by way of introduction, my name is Joy Einstein. I'm an attorney at Schulman Rogers, which is a law firm just outside of Washington, D.C. And we have about 100 attorneys. We practice all types of law. I am a partner in the labor and employment law practice group. So I work with a whole bunch of restaurants in my practice. And my goodness, it has been a long road for restaurants. I think now everybody is just getting to the point where, they're trying to right size their businesses again. The horizon is looking at least a little bit brighter. But yet all of these new laws keep coming out that restaurants are supposed to comply with. And I really feel for the position that restaurants are in, because it's like, hey, we are just trying to get some dollars in the door. We don't have hours and hours and hours to spend dealing with legal compliance stuff. So, we conceptualize this program with corporate payroll services to kind of say to restaurants, hey, you focus on the business and, getting customers back in the door, and we will focus on the law and run through all the important things that you should be focusing on in this upcoming year. So, that's sort of where this presentation came from. So she says I'm in presenter view. I'm not really sure. Does this look funny on everybody's screen?
We're able to see the presenter side. I'm not sure. If you go back to the share button, it should make it so that you will only show us the actual slide presentations. It'll be easier for them to view during the recording process.
Oh, gotcha. Okay. Is that better or worse?
So I would go to the, my screen just messed up. At the bottom, the very last presenting option. So next to where you can zoom in and out, to the bottom right. There should, so right next to zoom in, right now you're at 79%.
Sorry.
No worries.
Oh, I see.
Yeah, the very last option.
Okay. Oh no, that looks the same.
Hold on. That happened to me before. Oh, you can go to display settings.
Better?
Yes.
Okay. Oh, right. Lord. Hardest part of my job is the technology. Okay. Now I'm set. Okay. So I am just going to jump right into things. I think this presentation is meant to be interactive, and there's not all that many of you on the call. So please be vocal. You can take yourselves off mute and jump in with questions. Please use me as your free legal sounding board. And you are happy to send in questions via the chat function. My email address and phone number are also on the screen here, so you are more than welcome to use it. You can email me questions after the show, or you're free to pick up the phone and give me a call. So the first thing I wanted to cover today is the new American Rescue Plan Act. So this just came out last Thursday, so I'm rapidly trying to keep up with changing law for you all here. But just let me back up and talk to you all about how we got to the American Rescue Plan Act. So first, we had the FFCRA, which went into effect when Trump was in office. So I'm going to refer to these as Trump 1, Trump 2, and Biden 1, because I think it's just easier if we give them little short names. So under Trump 1, which was the first FFCRA package, hopefully you all listening are familiar that employers of fewer than 500 employees were required to give their employees 10 days of sick leave, and it was 10 days of sick leave with full pay up to $511 a day if an employee was sick or quarantining, or 2/3 pay up to $200 a day if they were caring for others. And then under this Trump 1, They were also required to give 12 weeks of family leave, emergency family leave. The first 2 weeks were unpaid, although they could use their sick time for those first 2 weeks. And this family leave was limited to situations in which employees needed to care for mostly children because their school or daycare was closed. So, and that was 2/3 pay up to $200 a day. So that was, Trump 1 was in effect from pretty soon after the start of the pandemic. And then it became no longer mandatory. It became voluntary when the Trump 1 sunsetted at the end of the year, so on December 31st. Then it became voluntary and extended through March 31st. So we're still in Trump 2 for just a little bit longer. Now we have the American Rescue Plan Act. So this is what I call Biden 1. So Biden 1 is extending Trump 2. So let's get into how this is being extended. The same types of employers are covered. So employers with fewer than 500 employees. Employees are immediately eligible to draw upon this emergency paid sick leave. So it is the same in many respects as the reasons why employees can take sick leave. So here, this is the same as under the FFCRA. If employee is subject to a quarantine or isolation order, if they've been advised to self-quarantine, if they're experiencing symptoms and need to seek a medical diagnosis, if they're caring for somebody else who is needing to quarantine or isolate, if their school or daycare is closed, or if they're experiencing another similar condition. So these first 6 factors, the first 6 reasons why employees can take sick leave are the same under Biden 1 as they were under Trump 1 and Trump 2. But now the American Rescue Plan Act has added 2 additional reasons why employees can draw upon this paid sick leave. So one is COVID immunization. So if they're both getting a COVID vaccine or recovering from it, they can ask for this emergency paid sick leave, or if they are waiting for COVID-19 test results. So here we see the emergency paid sick leave has been slightly expanded because it's adding COVID immunization and awaiting COVID test results as reasons why employees can take this kind of leave. The duration of leave is the same. It's still 10 days. If leave is taken for reasons 1 through 3 on the previous slide, it's the employee's regular rate of pay up to $511 per day. If leave is taken for reasons 4 through 6 on the previous slide, they're paid at 2/3 their regular rate of pay. And employers will still receive their regular payroll tax credit. It's the same tax credit scheme as under Trump 1 and Trump 2. So the American Rescue Plan Act also expanded the emergency family and medical leave. So again, the same kinds of employers are covered. It's still covering employers with fewer than 500 employees. Employees have to be employed for 30 days to ask for this type of leave, and employees can take the expanded family medical leave for, again, the same types of reasons as under Trump 1 and 2. If the school or place of care has been closed due to COVID-19 of their children, if their regular child care providers are unavailable, if a child is attending a school that's operating on an alternative day basis, and they've added these additional bases in here. So again, like on the previous slide, if it's COVID immunization, both getting the vaccine and recovering from it, and if you're seeking or awaiting the results of a COVID-19 test, and here's the kicker, all of the reasons for which an employee can take sick leave on the previous slide are now reasons why an employee can request expanded family and medical leave. So this is a big change here. There are now lots of additional reasons why employees can request to take family and medical leave act under the American Rescue Plan Act. So duration of leave, employees can take 12 weeks of leave. The time is included in and not in addition to the total 12-week leave entitlement. So what I mean by this is this works in conjunction with your pre-existing FMLA obligations. So for example, I had a pandemic baby. I don't know if you saw my co-presenter at the start of this presentation before grandma took her away, but I had a baby during the pandemic. So I used my FMLA leave to be out for the baby. I don't get a new allotment of 12 weeks of FMLA leave. It's a combined total. So if you do have employees, you know, like me, who are drawing upon parental leave, they don't get 12 weeks in addition to, you know, whatever they've taken for other reasons. The 12 weeks of leave is paid at 2/3 the employee's regular rate of pay, not to exceed $200 a day. And again, the first 10 days of this used to be unpaid. Now, under the American Rescue Plan Act, the first 10 days is paid. So that's a big additional benefit. And now the amount you can claim is $12,000 per employee accordingly. And again, you receive the same payroll tax credit. So both of these types of leaves under the American Rescue Plan Act remain voluntary. So, you know, under what I call Trump 1, it was not voluntary. If an employee asked for either of these types of leave, you had to give it to them. Now it's voluntary, but you're incentivized to give it to employees because you still get to claim the tax credits through September 30th of this year. The same eligibility and documentation requirements continue. Employees get a new bank of sick leave. So under Trump 2, there was no new bank of sick leave. So if employees had already asked you earlier in the pandemic to use 10 days of sick leave, they didn't get an additional 10 days. This is different now. Now employees get a new bank of 10 days. And the American Rescue Plan Act added a non-discrimination requirement. So this is important. Employers can't sort of pick and choose who they voluntarily decide to extend this leave to. So you can't decide that you will, for example, let your highest earners take this leave because you would get the greatest amount of tax benefits back. If you're extending it to one person, you need to non-discriminatorily just extend it to all of them. Although the non-discrimination component of this applies separately to sick leave and family leave. So it could be possible if you were to say, you know, our company policy is going to be that we will voluntarily extend the emergency sick leave to people, but we are not going to voluntarily extend the family leave to people. That would still be non-discriminatory because it's a neutral policy. So I've gotten a lot of questions from my restaurant employers as to how they calculate the amount of wages employees are owed under this American Rescue Plan Act, which is the same means of calculating it as under the FFCRA. It's a lot more difficult, obviously, if you are trying to figure this out for tipped employees than it would be for somebody who just gets an hourly wage or they get a salary. And it's kind of complicated and confusing. And so if you have questions about how to calculate the average rate of pay after this program, feel free to email me or you can chat me with questions and I'll try to take you through it. But basically, it contemplates using a 6-month look-back period. So you would look at the employee's total compensation for the 6 months prior to when they have asked for leave. So it's kind of, you know, even the 6-month look back period is difficult for restaurants because turnover is so high, and because in the previous 6-month period, and employees may not have been working. So it's kind of up in the air, you know, what employers are supposed to do in that scenario. I just advise employers to look back for the longest period they can look back. So if you can only look back for a 1-month period because you've only been able to bring your employees back to work at the restaurant a month ago, use the one month look back period. And then when you're calculating the total compensation, include tips to the extent they're implied towards your minimum wage obligations. So you would be including the tip credit amount in your calculations, and you would be excluding overtime premiums. You would not be including leave time or PTO in the calculation, the total calculation of compensation employees have gotten. And then you would divide the total compensation by the number of hours the employee worked during that look back period, again, not including leave or PTO. And the resulting sum is the amount the employee should be paid per hour if they take this American Rescue Plan Act leave. So again, I know it's kind of complicated when you're dealing with tipped employees. If you have additional questions about how to make your calculation, please let me know. I wanted to mention that the DOL has an absolutely great question and answer section on its website. It goes through a whole slew of commonly asked questions about the FFCRA, and they have the Department of Labor has not updated it yet for the American Rescue Plan Act, but it should be updating it soon. So I encourage all employers to take a look at the Q&A, and then the Q&A that involves how to calculate the rate of pay for your tipped employees is question 82, and I think that one is really helpful. So here is the link for all of you. I also wanted to cover COBRA under the American Rescue Plan Act. So this again is another very complicated and sort of dense provision that's been added here. So the American Rescue Plan Act is providing emergency COBRA relief. So now 100% of the costs of the premiums for COBRA are going to be subsidized. Hold on, I'm trying to look at chat simultaneously while I present. I'm just going to put the chats for this to the side, and then I'm going to look at them at the end so I don't get thrown off here. Let's see. So the new law is going to subsidize 100% of the cost of premiums for COBRA continuation for any employees who are terminated as a result of an involuntary termination or a reduction in hours. So this would obviously be a large burden on employers who are obligated to subsidize COBRA costs. But to offset that, employers are going to be reimbursed. Sorry, I got a frog in my throat. Employers are now going to be reimbursed for their COBRA cost as a credit against Medicare payroll taxes. So that's good news from employers. The premium subsidy is going to be excluded from income, and it can be advanced to employers if they would like. And we don't have any guidance as to how this is supposed to be advanced at this point, but we're assuming it's going to be the same as sort of the process if you would like to get the FFCRA leave advanced to you. The tricky part is that these COBRA subsidies are going to be available to eligible employees who enroll in COBRA starting April 1st, which is when the law takes effect, through December 30th, through September 30th, which is when it ends, and those who were previously offered COBRA and declined and are still within their 18-month window. So this is going to be a burden on employers. Employers are going to have to send out a supplemental notice to employees who are within their 18-month COBRA window to sort of check in on them to see if they want to opt into COBRA now that they don't have to pay anything for it. And so we are waiting for a notice form from the Department of Labor It's supposed to be pushing out a notice form that employers can use to send out to their employees. But I did want to put on notice everyone listening, because that's going to be potentially burdensome for employers to revise their form of COBRA notices and then also track down those employees who are within their 18-month window and send a notice out to them. All right, unless anyone has any questions about the American Rescue Plan Act, I am going to segue on to vaccines in the workplace. So if anyone's got a question, you are welcome to take yourselves off mute and jump in here. Okay, I'm going to segue to vaccines and the workplace. This is another hot button issue for restaurants. So vaccine eligibility for restaurant employees varies from state to state. And I know all of you listening out there are from different states, so it's sort of hard for me to speculate as to what your state guidance is. But, you know, some restaurants have done a good job advocating for themselves, and so they're included in Group 1B. So just check on that. Most states are requiring proof that restaurant workers qualify. So I'm advising all of my restaurant employers that they need to have a letter confirming the employee's employment status ready to go in case your employees need it. So far, I'm based in Maryland, and I actually have gotten dose 1, woohoo! And nobody asked me anything about confirming, you know, my employer, my group status. But I think you know, all employers should have a template form ready to push out to all of their employees just to be safe. And I'm getting a lot of questions from restaurants as to, you know, what they should make their policy. Should they mandate that their employees get the vaccine, or should they make it optional? And that's a really tricky, it's a very tricky question. So, you know, first of all, restaurants have been asking me, can they mandate that their employees get the vaccine? In general, yes, you can. And I'm going to get into that a little bit more on the next slide. And so the question is, should you? You know, it's an issue of morale. So I think, you know, a lot of the staff of restaurants tend to be younger employees. And so, you know, the risk to them is not as high. And so, and there's a lot of uncertainty about the vaccine in general. And so if you require an employee who otherwise might not be very excited about getting the vaccine to get it, it's going to be a blow to morale. And then, of course, if you require the vaccine, there's going to be a blow to staffing, because we're not at the point where everybody who wants one can get one yet. And so, you know, those are considerations. And there's always the threat that your restaurant could unionize. And so you always want to tread carefully around, you know, angering your restaurant workers, because you wouldn't want a union to take that as an invitation to step in. But on the countervailing side, in terms of health and safety, restaurants are obligated under OSHA to provide a safe and healthy work environment. And there's a real question as to whether restaurants are doing that if the employees aren't vaccinated. And there's sort of been widespread speculation in the legal community that this could give rise to tort claims. So let's say that you don't mandate vaccines in your workplace and one of your workers gets sick. Could they then turn around and sue the restaurant in some kind of tort claim? We don't really know the answer to that yet, and it would seem like it would be possible. We're just sort of waiting and seeing where the law goes from there. So there are a lot of considerations to factor into your vaccine policy, whether you're going to make it mandatory or not. But whatever your policy is, it's important to begin crafting your messaging now, because employees need to be on notice of what your policy is going to be. If you need help drafting a vaccine policy, whether mandatory or not, you know, I'm always here to give you guidance. Feel free to reach out, and I can give you some templates or some pointers as to how to put that policy into effect. I've gotten a lot of questions about vaccine incentives. So, if if you decide you're not going to mandate vaccines, should you, support your employees in getting vaccinated by offering incentives? That's sort of like the mid-ground approach that a lot of employers have been taking. I'm not going to mandate it, but I'm going to strongly suggest that you get the vaccine, and I'm going to offer you incentives to do it. So common incentives that I've had restaurant clients offering are like 4 hours of additional paid PTO to do it, some gift cards, other freebies. And it's important that you structure your incentive plan carefully because there are a lot of laws surrounding incentive plans. So, for example, you could inadvertently trigger the Americans with Disabilities Act. It has rules regarding voluntary wellness programs, and depending on how you structure your incentive, it could be deemed a wellness plan. Um, then, of course, if you require your employees to give you proof of vaccination in order to receive whatever incentive you're offering, that could trigger confidentiality and privacy concerns. So that's another factor. And then depending on how your incentive is crafted, it could trigger wage and hour implications. So, for example, non-discretionary bonuses are generally supposed to be factored into an employee's hourly rate for overtime purposes. So you could trigger that wage and hour obligation if these aren't structured correctly. So if you are thinking of doing a non-mandatory vaccine policy, but you want to incentivize employees to go get it, probably best to run your incentive program by legal counsel just to make sure that none of these other requirements are tripped. I've had other clients ask me if they can advertise that all of their employees are vaccinated or that certain employees are vaccinated. I think from a marketing standpoint, that sounds great. I would probably eat at a restaurant if they told me that all of their employees are vaccinated. But advertising individual worker status is a problem because you do have confidentiality and privacy obligations. And so disclosing, employees or just particular employees' vaccination status is probably not going to be okay. But general advertising, I think, is a good idea. So general advertising about all of the safety precautions that your restaurant takes, great. That all of your, if you want to advertise your incentive program, how you're incentivizing all of your employees to get vaccinated and the gift cards that you're offering or the extra pay that you're offering, great. I think it would be totally fine to advertise that, and it could be a great way to draw in customers. Questions about what happens if you put into effect a mandatory vaccination policy and your employee says they don't want to be vaccinated. It depends on the reason why they're objecting. So if an employee says, I don't want to be vaccinated because I'm a Jehovah's Witness and we don't believe in vaccinations. If it's a sincerely held religious practice, you do have an obligation to accommodate it if you can. And then the same thing if an employee says they're not getting vaccinated because they have a disability. And so, in that case, it's difficult. It's difficult for restaurants because you have to think about what kind of accommodation you could offer. So it's possible that you could accommodate them by giving them a different role. You could accommodate them by, I don't know, moving them to back of the house where all your back of the house employees, are vaccinated or something like that. You would have to think through and probably talk through with counsel what kind of accommodations you could offer. If there really is no accommodation you can offer them, like the only position you're hiring for is a server position, the only openings you have are for server positions, and you cannot let your servers be not unvaccinated because it poses a direct threat to other workers and also to your restaurant clients, then you could conceivably exclude them from the workplace. Again, this is probably not a decision you want to make lightly and talk to legal counsel about it, but all the information that we are getting from the EEOC is that you can exclude non-vaccinated workers from the workplace if you have a mandatory vaccine policy under certain circumstances. And then if you do require your employees to get the vaccine, you probably have to pay them for the time they spend getting the vaccine and trying to get an appointment or researching where to go, because it is a work requirement at that point, and wage and hour laws generally require that you have to pay for mandatory events like this. I've gotten questions about whether you can require that your employees tell you that they're vaccinated, and yes, you can. You can require all employees to report to you that they've been vaccinated. Let's see, what other common questions? Move this over here. Yes, you can require proof that the employees have gotten vaccination. And then again, employers are supposed to be keeping medical documentation in separate files and protecting those files. So if you do request proof of vaccination, you need to treat those proof documents confidentially. And if they say, no, I haven't gotten vaccinated, you shouldn't probe into why an employee has not, because that could trigger protections under the Americans with Disabilities Act. I've gotten some questions about whether, if employers, are able to get their hands on vaccines, can they offer an employer-sponsored program? Yes, you can. And then in order to require the COVID vaccine in general, you have to have a reasonable belief that employees will pose a direct threat to the health and safety of others. Basically, right now, because the virus is still so widespread, we're basically just assuming that all employees will pose a direct threat to the health and safety of others. This could change, though, as we approach herd immunity. So if you are going to require a COVID vaccine, you probably need to revisit your policy as we get further along in our trajectory of vaccinations to see if there's no longer a direct threat to the health and safety of others. Oops. So I'm going to finally, now that I'm so far along in my presentation, segue away from everything COVID related. So if anybody has any additional COVID questions, pose them to me now, because I'm finally going to move away from this and jump into discrimination and harassment.
I do have a question on the vaccine.
Yes.
First of all, congratulations on your baby.
Thank you.
Are you able to ask the question for potential new hires? So are you able to ask the question on include an app on your application? Have you been vaccinated? Yes or no, and
yes,
make a determination based on
yes.
that. Okay.
Mm-hmm.
Thank you.
Okay. All right, so this presentation was meant to be, all of the issues facing restaurants in 2021 that restaurants should be paying attention to. It kind of got hijacked by COVID because the new American Rescue Plan Act just came out. But I did want to touch upon other issues in the employment realm that I think restaurants should be paying attention to in 2021. And so discrimination and harassment continues to be one of those issues. So in September of 2020, discrimination charges were filed against one of the leading national restaurant brands, alleging discrimination based on lawful tipping policies, so not even unlawful tipping policies. But the charge claims that paying employees by tip credit results in pay disparity because one, women, and two, people of color historically earn fewer tips. And then after this EEOC, this massive EEOC charge was filed in December, Workers in various other restaurant locations filed additional charges alleging the same thing and adding that they were not assigned the busiest shifts or sections with the best seats. So the EEOC is taking this very seriously and considering whether even these kinds of things, violate discrimination laws. So I think that that's, a scary proposition. It should be a scary proposition for all restaurants out there, because these are things that all restaurants do. All restaurants, generally pay people by tips, and then all restaurants have to make decisions as to what sections their servers are serving and then what shifts they're getting. So, I've had clients ask me, what can we do? We don't want to be the subject of a similar EEOC charge or, maybe eventually a lawsuit related to discrimination. So what can you do? You can move from tip sharing to tip pooling. So, every sort of house runs their tip pool, their tip share differently. But if you move to tip pooling, this eliminates patron bias in tip amounts. All the tip amounts are going to be pooled together. So, it doesn't matter that a patron is going to tip a white male higher than it would an African American female. This would also eliminate bias in section assignments. So, I'm throwing this out there as an idea to restaurants. I know that changing to tip pooling like this creates a whole slew of additional potential problems. So, the biggest one of them is going to be blows to employee morale, because you're going to have your highest tip earners who are going to hate being in a tip pooling arrangement like this. But I think if you work carefully on your messaging and you get employees to buy in and you make them understand that this change is necessary because some employees are being disadvantaged through no fault of their own, hopefully that will be enough to quiet the negative blowback. And then two, establish objective scheduling procedures. And this is difficult, because making the schedule at any restaurant is hard. So, one strategy is to rotate the best shifts. Again, this creates its own problems because some of your servers, are really going to want predictable schedules. And so if you're rotating the best shifts, like they only work the Saturday shift 2 times per month, their schedule becomes less predictable. Or you could look at assigning each server at least one desirable shift per week, or designating which shifts are quote desirable shifts and then making sure each employee is assigned one of them. But I think certain things are really key in avoiding EEOC charges. One is obviously transparency. All your employees need to be aware of how these shifts are being assigned, and then you need to train your managers. Managers have, a ton of discretion in how they assign shifts, and quite frankly, they play favorites. And I think you need to train your managers and say, hey, the way you assign schedules can actually subject us to liability. So we're going to need you to use objective procedures in doing it. And then I think business is slow now. So to the extent that you have some time, you really should be spending that time thinking about whether it would be possible for your shop to change from tip sharing to tip pooling. And, now is a great time to look at the way shifts are scheduled and assigned and to train your managers. If restaurants are going to be slow, use the slow time to really think about your policies and revamp them. I wanted to cover new federal laws too that I think every restaurant owner should be on the lookout for in 2021. So, towards the end of December, Trump pushed through some changes to the 80-20 rule that all restaurants were very, very excited about. So he did away with the 80-20 rule. So the 80-20 rule, just to back up in case anybody out there listening is not familiar with it. there are non-tip generating components to every server's role. So, rolling silverware or filling up the salt shakers, those are non-tip generating duties, but they comprise part of any server's role. And so the rule is that so long as servers spend about 80% of their time on duties that generate tips, so serving customers, it's okay if they spend 20% of their time doing non-tip generating tasks. Now, this 80-20 rule has been the nemesis of restaurant owners since the beginning of time because there's no practical way to track, how much time employees are spending on non-tip generating duties. Like if they, fill up a salt shaker in the middle of serving tables, how do you track that? And so Trump announced that it was going to be revoked, and all restaurant owners were very happy. And then came Biden, and he has put a regulatory freeze on all changes for at least 60 days. And so we're just sort of watching and waiting and seeing what is going to happen with this 80-20 rule. So I should mention that the employment group at Shulman Rogers at my law firm, we push out employment alerts. So this is one of the things that we are watching. So if you would like to get on our alert list, as soon as we have an update on this 80-20 rule and what's going to happen to it under Biden's presidency, we'll push out an alert. Just let me know if you'd like to be added to our list. And same sort of thing, we thought that there was going to be an expanded tip pool law. So again, this was one of President Trump's sort of 11th hour changes. There was going to be a new regulation in place that if employers did not take the tip credit, then back of house employees like your chefs and your dishwashers would be permitted to participate in the tip pool. This wasn't a huge sea change because I don't think there are not a lot of employers who don't take the tip credit. But at the same time, there were a fair amount of restaurants excited about this. And again, we are waiting to see what happens. We're waiting to see if this expanded tip pool regulation will go into effect because, again, this is also part of Biden's regulatory freeze. So we're watching and waiting and listening to see what Biden will do with this. So I have more slides to cover. I've gotten myself totally bogged down with COVID stuff. I talked way too much about COVID and way too little about all the rest of it. But I do want to turn things over to payroll because I don't want you to not have time to cover your slides. So, let me just, before I jump away and turn things over to payroll, I know that this is a lot. So I've talked for a long time, and believe me, I could talk for an hour more. We're going through crazy times. There's a pandemic, an economic roller coaster, a change in administration, and there's Me Too and Black Lives Matter and anti-Asian sentiment. And it is a lot for restaurants to keep up with. So I just want everybody out there listening to know that there are resources to help you. I know that this has been like a doozy of a year. So like I mentioned, Shulman Rogers employment team, we push out alerts on a regular basis that will come into your inbox to keep you abreast of all the important changes affecting the restaurant industry that you would need to know about. We also put on webinars like this. So if you want to chat me your email address or send me an email with your email address, I will add you to our alert and webinar list to sort of keep you looped into all these things to try to make your lives easier. As a result of the pandemic, my employment team also devised some more budget-friendly options. So we now offer a subscription plan. So basically our subscription plan is you pay for 2 hours of legal work, but you get 5 if you sign up for a year's worth of employment counseling. I think a lot of restaurants have taken us up on it because, again, paying for 2 hours of legal time a month, but you get 5 hours worth to ask all your questions, or, we can put the 5 hours to drafting your vaccination policies or your social distancing policies, answering questions about this American Rescue Plan Act. We've had a lot of takers in it. And then we have a whole bunch of flat fee packages for your trainings or your handbooks or your policies. So chat me or email me if you want information about budget-friendly options that we have to help restaurants. So I am now going to turn it over to Corporate Payroll Services to make sure that you cover the things you need to cover in this presentation.
So the only thing for us I wanted to highlight was touch on the first few slides, where she was discussing the FFCRA payroll tax credit, so the sick leave and the family sick leave, FMLA sick leave. So the payroll side, the one thing is, if you have not used that before, please do communicate with your payroll specialist what the sick pay is if you're looking to get a credit for that, because we have to set up a special code for you. It's a new pay type that would have the following description. It would either be FFEE to indicate the employee part, or DEP for dependent, or FMLA for the FMLA description. And just as she went over the amounts that you're allowed, we'll limit the pay types will have a cap based on what the pay is under, and then you'll receive that against your 941 tax payment. So if you're looking at the slide right now, it looks like our sample employee, Jessica, she's getting a sick pay for $180. And then the OASDI, so the Social Security portion for right now, is charged back as a credit to you, given back. Starting April 1st, you're getting back the FICA. So it's going to be combined Social Security and Medicare. But up until April 1st, it's just the 6.2% credit that you get. And then the reduced line, the $82.89, that's the amount that you aren't able to get back on payroll. So we would have to send over the form 7200 to the IRS so that you get that refund back. So on payroll directly, you're getting up all the tax liability you have up until the 941 taxes. So anything over your 941 tax liability on that specific payroll will be requested on form 7200 to the IRS, at which point they'll send you a check. I think right now on average they're about 30 days behind schedule from the time it's filed. So just we would have to give that time, and then once the quarter ends, it starts over as far as 7200 reporting goes. And that's all I wanted to share. And I think, Kay, if you go to the next slide, the sample of the 7200 form we file is on there. So the last line, so this is one form just split in half. And you'll also receive a copy for your records. Okay, thank you. And if you have any questions, please chat us.
All right, does anyone else out there have questions? We have about 5 minutes left, so if you have any questions, feel free to speak up. Okay, well, if no one else has questions, I'm going to hang out on the line for a little while in case anybody is afraid to ask their questions in front of the big group. Otherwise, thank you all for attending. I really, really appreciate it. I hope you found it valuable. And Kay, I think you're going to be sending out a link to the recording, right?
Yeah, so I'll have a link sent out either later this afternoon or tomorrow morning, the latest, but there will be a link with a recording and a PDF of the slides.
Great.
And thank you so much, Joy, for helping us today. And I will also send out your contact information to everyone that attended when I do send out the recordings. And if no one has any questions, again, Joy will stay here for a couple minutes, and then we'll just sign off and send everybody a recording.
Okay, great. Thanks, everyone.
Thank you. it seems like we'll most likely be good to go.